Good evening, everyone, and welcome to today's workshop on the basics of mooting. We are delighted to have with us Ms. Chandni Sahani, a final year student at Government Law College, Mumbai. Ms. Sahani is an exceptional mooter with an impressive record of achievements to her name. She has won several accolades, including Best Speaker and Best Team at the NMIMS Hyderabad National Moot Court Competition, Best Team at the 6th NMIMS International Arbitration Moot Court Competition, and Best Team at the 6th NMIMS International Arbitration Moot Court Competition, and Best Team at the second Kocher & Co. RMNLU International Arbitration Moot, to just name a few. In addition to this, she has represented GLC at the prestigious moot court competitions such as Monroe E. Price Media Law Moot Court Competition and our very own MC Jagla Memorial Moot as well. She has consistently excelled at intra-college moots as well. With her experience and insights, I am sure today's session will be very helpful as you all prepare for your Freshers Moot Court competition. Over to you, Chandni.
Hi, thank you so much, Tanvi. Thanks for that. Just starting off, guys, I'll keep this very short. After that, if you all have any questions, please feel free to ask me. As Tanvi said, honestly, I thoroughly enjoy mooting. And I know a lot of people will tell you things like, okay, you're in GLC, maybe you're, say, disadvantaged when it comes to mooting because we don't have resources or we're not that much in touch with our seniors, anything along those lines. I think all of that is false. Honestly, you have an advantage in terms of having more time compared to others. At least I felt that I did, which allowed me to moot a lot more, say, in comparison to my peers in other colleges. So I think if you're in GLC, you should most definitely exploit this opportunity, exploit the extra time that we may get in terms of, indulging more in extracurriculars such as mooting. And just starting off, I mean, I'm supposed to give you all like just a basic since it's just your freshers moot and it's the constitutional law moot. I think I'll just run over through the basics. The first thing that I do when I get a moot proposition, now this is a very personal thing that I do. It's contingent on whether you all find it helpful. I always go ahead and see whether the particular issue has been covered before, whether it's in the news or anything along those lines. Because usually a lot of these propositions will be based off something that's happening in real time at the moment. I think most of my grand moots or even my IL and my IM, most of them were based on real time events. Like the first IL I did, for instance, was on the Israel Palestine issue. Some of the grants I've done have been, say, on the basis of whether law firms should be allowed to advertise. So most of them are generally based on something that has happened or, something that's in the process of happening. It's in the news. So I find it generally very helpful that before delving into this, in terms of your arguments, in terms of your research, to just get like an overview of what this is about and to build an opinion before you approach it like a lawyer. Just build a common layman's opinion on what basically is the proposition about. So I think after that, after you get an idea of what this is about, you can go ahead and identify specific law that it's based on, right? Whether there's something specific in terms of, say, a legislation that's mentioned, in terms of y'all are doing a constitutional law moot, so naturally I'm guessing y'all will have something along the lines of, say, an infringement of your fundamental rights, a generic thing. So what you can do starting off before delving into issue specific research or even site specific research, you all must have been given your sites by now, whether you all are petitioners or respondents. So before delving into or before like forming an opinion on the basis of the site, what you can do is just read the law on it. See what the law says, go through the legislation or the provision that's in question, and then go ahead and read whatever landmark judgment has been passed on this. I think that will help you know whether that particular issue has been decided already by the Supreme Court or by any High Court, and whether there's a way for you to differentiate your particular set of facts from that landmark judgment. So I think after you get a generic overview and a common understanding, you can go ahead and delve into the specifics and understand what the law says on this particular thing. And now moving on to say specifically now site specific research, when you'll come to that, since this is a constitutional moot, I mean, you all will have, say, infringement of your articles 14, 19, and 21. I think this is the most common thing that I've seen. The freshers moot that I did on, for instance, was on the intermediary rules of 2021, the IT intermediary rules. and that was my freshers proposition. It was on, again, infringement of Article 14, 19, and 21. So what do you do as a petitioner specifically? I'll just give you like a brief on what you can do sidewise. If you're the petitioner, then naturally you'll be arguing that there has been an infringement, and if not infringement, at least say a curtailment of the petitioner's fundamental rights. So you have 14, for instance. Now, under 14, 19, or 21 for that matter, once you look at these landmark judgments, for instance, you have Menka Gandhi versus Union of India. That's the most common judgment when it comes to the Golden Triangle rule. According to which, say, 14 and 19 of the Constitution are violated, then as a consequence, you'll have an infringement on of 21 as well. So you see that landmark case law. On 14, you'll find abundant of case laws. And I think that's the best thing about consti moots. I love doing constitutional law moots because there's so much room for interpretation. There's so much room for research. There's an abundance of judgments. So as a petitioner, you go ahead, you find these landmark judgments. And generally, when it comes to infringement of a particular fundamental right, you'll have a judgment laying down a particular test for such an infringement. You'll have, say, three things. If all of those three things have been met, then there's an infringement of your right under that particular article. As a petitioner, you'll find judgments that say this. You'll show the court how these three criterion have been met, and therefore there has been an infringement. As a respondent, I mean, the only thing as a respondent that you do is you show that whatever action of the government that's in question, or any legislation that's in question, that legislation is will fall under the purview of a reasonable restriction. It's a well settled fact that all fundamental rights are not absolute in nature. So naturally, there are cases wherein the government or the state may have some sort of restriction when it comes to these particular articles. So as the respondent, you go ahead, you find case laws on what is a reasonable restriction under a particular article. For instance, on 19, you'll find a plethora of jurisprudence on, what may be considered as a part of 19.2. So Article 19.2 is on reasonable restrictions. You'll find a lot of case laws on that. As respondent, you go ahead and you show how the action of the state in your particular set of facts will fall under that criteria, and therefore it's not an infringement of fundamental rights. So this is just basics of how you research. And in your freshers moot, you all don't really have a memorial round either, so I won't be delving into how you go about your mem. This is just in terms of how to tackle oral arguments. After you're done with researching, um, I will come to how to basically structure your arguments. Now, just briefly, I'm just going to briefly mention two ways of how people generally structure their arguments. And this is a little complicated. I only knew about this in my third year because I went ahead and used it for my memorials and to some extent for my oral arguments as well. There are two methods. One of them is called IRAC and one of them is called CREAC. Now, IRAC is basically, the full form is issue, rule, application, and conclusion. And CREAC is the same. It just starts off with your conclusion. What people generally do when it comes to structuring your particular arguments, I mean, you can structure them the way you want and what you think would be best suited, but just to have some sort of coherence in the way you're drafting your arguments, I think it's best to follow this method. So IRAC, you lay down the issue before the court first, whatever your issue is. Say it's so and so action of the government has infringed upon the fundamental rights of an individual. That would be your issue. Then you go about the rule. You say, mention Article 14, you mention some jurisprudence on Article 14. Then you come to application, which is the most important part, and you should come to this as soon as possible. This is you basically applying those judgments and applying that particular law to your own set of facts, and you go ahead and show why a particular conclusion should be held in this particular case, or why the court should rule in your favor, so to speak. And CREAC is basically laying down the conclusion first, then the rule. And this is usually, I think, more helpful for oral arguments because you don't want to start off by just saying what the issue is. You want to start off by saying what you think should be held in this particular case, and then you go ahead and explain it, so the judges also have an idea of what you plan on saying or how you plan on essentially structuring your arguments in that sense. And so this is basically all your pre-round pre-round preparation, if I may call it that. When it comes to the rounds in itself, um, now there are a lot of things that you have to keep in mind when you're arguing. See, when it comes to mooting, for instance, or even for instance, your freshers moot, what they're looking for may not certainly be, say, an exceptional argument or some crazy point of law that you came across. The only thing, or at least majorly what they will be judging you on, is your manner of speaking and how you put, basically how you put your point across, or how you put information across to the bench in front of you. How it'll start off generally is you start off with your greeting. You start off with a greeting. For instance, names I'm guessing y'all are not allowed to say, so you can start off by just introducing yourself and saying that you're counsel for the petitioner in so and so matter. Just mention both of the parties. Then you go on to ask them whether they want a summary of your facts. Now, this is one thing I think that's been enforced into me by my seniors also. Every time I've asked for help, your moot proposition, you should know it inside out. You should read it again and again. Your facts should be very clear to you. The law you can still falter on in that sense, or maybe you can refer to when you're asked a question. But your facts, if you're asked a question on your facts, then you should be thoroughly clear on it. You should be very clear on your facts. You should know the page number, preferably even say the paragraph number. If they ask you a particular thing, you should be able to redirect your judge to that particular page or para number in an instance. And so how you do it is you essentially say that, may I draw your attention to paragraph number this, or may I request you to kindly turn to page number this of the moot proposition. That's how you basically direct a judge to a particular paragraph. But again, facts are very important. So you start off with your greeting, you introduce yourself, you ask them whether they want a summary of the facts. Now, most judges will ask you this. Mainly, there are two reasons. It's either because they do not know the facts very well, they've not really read the proposition, and they want to be, they want you to just refresh the facts for them. Or second would essentially be them just seeing whether you know the facts, because it's also a skill, right, to just summarize a whole moot proposition in say 5 lines or within a span of 15 seconds. That's also something they judge you on. So um, generally a judge will ask for a summary from you, and you should have one prepared. Just 15 seconds or max say 30 seconds of whatever your facts are. Just tell them in brief. And after you're done with the facts, you move on and you ask them if you can move on with your submissions, if you can move on with your contentions. Now, small things like how you refer to them, again, very, very important. You get marked separately on this. Now, whatever research you've done, whatever judgments you're citing, those are separate marks. The way you're speaking, how you're addressing them are, again, you're graded on them separately. So if it's, say, a male judge, you'll say your lordship. If it's a female judge, you'll say your ladyship. Now, some people also prefer my lord. It's a little classic way of say addressing the judge. I do it sometimes. It's up to you completely. But stick to one greeting. If you're calling them your lordship in the beginning of your submissions, then try not to change that, maintain that consistency. You can ask them before your arguments. Honestly, this is something people do. You can ask them that permission to refer to the bench as your lordships. They'll say okay, then you move on. You address them as your lordship for the duration of your round. After that, like I said, you give a summary of the facts, and then again you take their permission to move on to your submissions. Now, when you're giving your submissions, again, from what I know about your rules, you all have 6 minutes per side. Now, that's not a very long time, especially if a judge is going to ask you questions. So don't beat around the bush too much. Don't talk too much about the rule aspect. If there's a landmark judgment on it, just cite it and move on to how you've applied it to your particular set of facts, because turns out you're just talking for 4 minutes. You get to the important point at the fifth minute, and you end up not having enough time to essentially show the judge how you've applied the law in a particular manner, and you don't give them enough time for them to ask you questions. So I think I'd suggest right off the bat, lay down the law and just directly move to your arguments. And do not save your best argument for the end. 6 minutes is a very short span of time. just get to the main point. Whatever best point you think is required for the judge to rule in your favor in that sense, start off with it. If time permits, then feel free to bring in your ancillary points. Or if you think something else is important, then surely you can even request the judge, for instance, if you can have an extension for a minute or so, something along those lines. But start off with your strongest point and just harp onto that. Let them ask you questions on that. Let them be satisfied with the way you answer those questions, and the rest is contingent on how much time you have left. Um, in terms of answering questions, I think this is very important. This is generally like a make or break thing. Like you could have great arguments, you could have started off amazingly. They ask you a question and you falter, or you're scared in that sense to answer it. Then that could be like a make or break thing. I think at this stage, what they're basically judging you on is how confident you are. So when you're asked a question, just don't evade it. Don't evade it. If you want some time to think about it, tell the judge honestly. Tell them, can I have a minute to answer your question, your lordship? They'll say, okay. You'll say, much obliged. And take a minute, gather your thoughts, and then answer. There's no need to panic. Avoid fillers like all of that too much. It's okay. I say it all the time. That's fine. But try to avoid it. Instead, just take time. Just be honest. Tell them you need, say, 30 seconds to answer a question, and take your time, gather your thoughts, and then go ahead and answer it. If the judge will ask you something and you have no idea, like no idea whatsoever, don't beat around the bush. They can definitely sense it since they're judging you. They would not like it. It would be like wasting time. If you don't know something, there's a phrase where you essentially plead ignorance before the court. You want to say that, you say it. If you still want to try to answer, feel free to just steer clear of saying something terribly wrong. If you're sure that what you know is incorrect, don't try to answer it. It's okay. Just admit to not knowing it, or admit, or tell the judge, say you'll read up on it later, whatever the case may be. Don't answer incorrectly if you know it's blatantly wrong, and don't beat around the bush also. Just answer the question directly, whatever you think is the case. And naturally, you're allowed to have an opinion. It's not like whatever you're arguing, all of it does not always have to stem from a particular judgment. Sure, you should have authorities. Again, like I said, there are points for greetings and the way you're talking. There are points for citing authorities. There's a specific section for the judge to mark you on, which is on the basis of whatever law that you state and whatever judgment that you state. So you should have judgments. But when you're framing your arguments, use common sense also, right? Use logic. Just frame it in a way that's easy to understand. Don't try to make it complicated. Don't make like a circuitous argument. Don't confuse the judge, and don't confuse yourself essentially. Just keep it simple. Tell them this is the law. This is how it would be applicable in our set of facts, and therefore these are our prayers before the court. Just keep it simple. Don't make it too complicated. And but like I said, answering questions, I think that's very important. Try to be confident in what you're doing, and naturally confidence will only come after you've prepared enough. You can't just be confident about something. So facts, like I said very clearly, always be very, very thorough with your facts. Even before maybe looking at the fact sheet, you should remember that, okay, this particular thing is on this page number, for instance. Just be very, very thorough with your facts. And landmark judgments, even if you're not citing any, because say it's in favor of the other side. I'm the petitioner. There's a judgment, there's a landmark judgment which is in favor of the respondent. I'm naturally not going to cite it because it's not going to be helpful in my case. But you should know about it. You should know the facts of that judgment very briefly. You should know the ratio, what was held by the court. Because chances are they will ask you, right? They'll ask you, okay, you're arguing this, but there's a judgment that says to the contrary. What do you have to say about that? Chances are they will ask you that. So you should be prepared. This is again in terms of a basic research. You should be prepared regardless of whether that judgment is in your favor or not in your favor. um Apart from that, I think that's pretty much it. I'm open to questions. I think someone's already asked me something. I will just try to answer that. Can the council add any issue? First one, I mean, no. If they wanted to give you that freedom in terms of the issues being drafted, then usually a lot of moot propositions come with that caveat which says that you know, participants may frame their own issues. So if they've given you issues, they've culled out issues specifically, try to stick to those issues. Maybe you can change the order, maybe you can divide it into sub issues and say that I'm going to address this part. This is only when you've got two speakers, though. You're for your freshers, you're just one speaker. So no, I you shouldn't try to not divert from the issues that they've already been given, because the other side would also be arguing on the same issues. If the moot proposition stated as parameter to refer to X or the one provided in the proposition. I mean, parameter means the same thing. So for instance, if you have um any act, for instance, you have any article and they have reproduced it in the annexure of your proposition and they've said it's parameter. So it would be the same whether you refer to the statute in your proposition or whether you refer to the real one. It would be the same if it's parameter. Um, Someone's raising hands, Riddhi. You feel free to like unmute and ask me whatever your question is.
Hello. Yes,
Yeah,
I know
hi.
you explained the structure, but I kind of lost track of it in the middle. So, just for clarification purposes,
Hmm.
we can frame our arguments like summarizing our facts first and then going from issue 1 to 3 and the conclusion, right? Or is there anything else to add?
No, no, that's correct. That's exactly what you're supposed to do. You start off, you say your greetings, you introduce yourself, you ask your judges whether they want a summary of your facts. If they say yes, go ahead and give that. If they say no, then ask them if you can move on to your submissions. And after they say yes, go ahead. Start off normally that I'll first be addressing issue number one, which is so and so. On this particular issue, the court in the past has held blah blah, whatever it is, any judgment that you want to cite. So that would be the order. Prayers, I mean, you barely have any time, but know what you want to ask from the court. Prayers are important. For instance, if you want the court, if it was a case of, say, preventive detention, anything along those lines, you'd naturally be asking the court to exercise its powers and issue a writ of habeas corpus. For instance, some judges may ask you at the end, right, what are you looking for? What do you want the court to do? So you should have your prayer ready. Chances are they'll not ask you this. 6 minutes is too less of a time. But if you still have time left at the end, if you're done in 5 minutes, 5.5 minutes, then ask them, would your lordships like to hear the prayers from the council, and then go ahead and see what are prayers that you want. But that would be the order, nothing in addition to that.
Got it. Thank
Does
you.
No worries. Does the argument need to include all three questions, or should we only choose one of the three questions? By questions, do you mean the issues that are framed? Someone's issues. No, you have to address all issues. I don't think they must have given you a choice. You have to address all three issues if they've given you three issues. So just also structure them in a way that you can try and address all three also in the limited amount of time that you have. Don't spend too much time on one particular question and anything of that sort. Just structure it accordingly. Does the respondent have a prayer, or is it just... No, generally it's that. You're correct. Someone asked me whether the respondent has a particular prayer or it's essentially just dismissal of the petition, but it's essentially just that you set aside the particular petition as the respondent. That's what you pray for. Mm, yep. Okay. Does anyone else have any questions? Anything in particular? How do
Um,
you... Yeah,
excuse,
sure, go
excuse
ahead.
me. We have to mandatorily read the entire judgment before we go to the competition, before the day of competition.
The judgment, you mean any a landmark case that you find on it? Is that what you mean?
For example, I have to sign up.
I'm sorry. Can you repeat
Hello,
yourself?
hello. Sorry for
Yeah.
inconvenience.
No,
Actually,
no,
I
no
want
worries.
to, for example, I have to cite the Menka Gandhi judgment. So I have to
Right.
read the entire judgment, or just I should know the summary of the judgment or particular main observations of the judgment.
Honestly, the correct answer would be me telling you, yes, read the whole judgment thoroughly, but that's not always possible, right? So just no one's going to ask you unless you're stating something that's say controversial, something the judge doesn't agree with. No one's going to ask you particular paragraph numbers from the judgment. You yourself can maybe cite it. Sometimes in our arguments for emphasis, you'd want to read out a particular finding of the court, a particular paragraph, so that way you should know paragraphs that are important for you to cite, right? If you're especially if you're citing them verbatim in your oral arguments. So you'll say that the court in so and so judgment in Menka Gandhi versus Union of India, in paragraph this, observe that, and then you read that paragraph. But you should know the facts in general. I would not say that you should know the whole judgment thoroughly. If you have the time, then why not read the whole judgment and just keep in mind whatever important aspects that you'd be using in your argument.
Okay, thank you. And second one, my question is, if I know a particular judgment, which is applies the same law, applies the same guidelines, but it is not in the context of my fact, but it is in a applied in the same law, means
No, no,
one
yeah.
judgment that.
Hmm.
Uh, so can
You
I
can
cite?
certainly use them. You can certainly, I mean, a lot of times you may not find a judgment on your particular facts, right? You'll have find something, say, on one particular aspect, or it could be like a generic judgment. Like you could have case one and the Bharti, you want to cite that, you want to cite something for basic structure. These may not be particularly factually relevant in that sense or factually the same, but you'll have to cite them to lay down the law. You'll have to cite them to just say clear a few concepts in that sense. You can certainly cite judgments that are different in terms of facts also, but if a judge asks you why is this applicable here, then you should have an answer for it. You should say that the facts may be starkly different, or the facts may be not similar, but the finding would still apply to the facts, or the ratio of the court is what matters here. You should have an answer ready to just justify why you're citing that judgment if it's very different from your facts. That's all. Otherwise, you can certainly cite judgments that are not similar in
Okay,
fact.
thank you so much for your guidance.
No, no, no worries. How do you phrase the prayer as a petitioner? As the petitioner, I mean, you just say like this one line in terms of in light of the arguments put forth. Um, we as petitioners request this court to, and then you say a particular prayer, say to issue a writ of habeas corpus, or to say strike down this particular provision as unconstitutional. This would be fact specific, how you phrase your prayer. Which sites do you recommend for research? Um, Honestly, I don't have any particular go-to sites when it comes to research. I start off with a normal Google research. Then wherever that takes me, you'll generally find a lot of articles. I mean, you'll find a lot of law firms writing on this. I personally find those articles quite useful because they do have judgments. They do give you like a background on that particular issue. So I don't personally have a particular site that I would recommend or I would use. But a good starting point would be like even papers that are written by in a lot of these journals by different law schools. Anything along those lines would be like a good starting point to gather a few judgments, to build your own opinion or to build your own arguments, I mean, on something. Since there are no memorials, how do we know what the other side will cite? I mean, you will not know what they'll exactly cite before your oral rounds. It would depend on your research. I mean, both of y'all would be looking at the same thing, right? At the end of the day, the facts are the same, the law is the same. So chances are whatever they are going to cite, you will come across it. And that's why I said that if there's a landmark judgment on this and it goes against you, then have an answer ready for it. maybe the judge won't ask you, but they'll cite it, the other side. For instance, the respondent will cite it when you're the petitioner. Then, um, or vice versa. Then your rebuttals as the petitioner, for instance, then you'll want to address it, right? If you'll want to address that judgment, you'll want to say something like, it's not applicable here, or the facts are different and therefore it would not apply here. Something along those lines. Can you briefly state how we go about the research? I wasn't able to get that part. Sure, no worries. I mean, like I said, research, honestly, I really don't have a particular manner in which I research. I really just start off with a normal Google search. Now, whatever I come across, I'll come across some article by the Hindu or by Indian Express. I'll look at it. I'll see why it's been in the news. Is there a particular reason something happened? Now, those articles will mention a particular judgment. Then I'll look for that judgment specifically. I'll read the facts of that judgment. That judgment will have other judgments that they've relied upon. So you just go from there. It's just this a flow that you get into when you start reading on something. So I'd suggest just start off with a normal Google search. You'll come across some judgments. Go ahead and read those judgments, find out what they're saying. In those judgments, if there are other judgments that are cited that are explaining something or anything along those lines, then go ahead and read those as well. So there's no particular way of going about research. Do it the way you find comfortable. But to me personally, I think it's very helpful to just have a generic idea of why this issue is even a moot proposition in that sense. Since while referencing a case as a part of your argument, how should you structure it? Should you include the judgment and the relevant facts or the arguments of the parties? Okay, that's a good question. I honestly still don't know what the right way is. So someone asked me, when you're citing a judgment in your arguments, how do you cite it? Do you just do you say the facts first, or do you say what the arguments of the parties were, or do you only discuss the ratio? Um, I mean, I don't know if still have this figured out completely, but completely depends on what you want to focus on. If you have a judgment where the facts are very similar to your particular case, then you'll want to focus a little more on the facts, right? You'll want to say, okay, so in this judgment, this happened. And then you can say that this is starkly similar to our facts. And after that, you can go ahead and mention that in this particular case, the court observed so and so. And then it becomes clear that you're saying the facts are similar. This is what was held, so you hold the same thing today in this proceeding. So it completely depends on what you want to focus on. If the facts are not similar, maybe move on directly to the ratio and just say that, this point of law has been settled by the court in the past in so and so judgment, and this is what was observed. And we submit that the observation of the court should apply to our particular facts also. So it'll completely depend on what judgment you're using and how you're using it. Is legal language or use of Latin maxims important in your arguments? No, it's not that important. Like you don't have to throw in like a lot of judgments. You don't have to throw in a lot of legal maxims. I don't use a lot. I don't personally use Latin maxims because they're hard to pronounce. So I would rather steer clear of them unless it's something very important, or I don't know. You want to say audi alterum partem? Sure. You want to say something like that? It is important when it comes to an opportunity of hearing. If your facts warrant it, then go ahead, use the Latin maxim, say a few landmark judgments on it, and finish it off. Otherwise, honestly, the simpler you keep it, the better. Don't complicate it. Don't use too much of, I don't know, flowery language, if I may call it that. Keep it simple, essentially. Will we get 6 minutes only for the first round on the 11th, or is it the same? I think someone from the MCA would be better equipped to answer this. I'm not sure about this thing. Rushil, someone's asked, will we get 6 minutes only for the first round on 11th, or is it the same for all rounds?
All the participants will get 6 minutes for all the rounds of the arguments.
Right. Okay. So you have your answer on that. Also, do we use the same argument? that's completely on you. Now, in your first round, in your prelims, um, the judge will ask you something and you don't know the answer to it, but you still qualify to the semis. So for the semis, naturally, you'll want to include this in your argument. So you'll want an answer ready for it, for whatever the judge has asked you. So feel free to change your arguments according to whatever suits you. You can definitely change it in the next round if you want to incorporate something. Since the acts in the prop are pari materia and only the prop mentions few sections, what is the scope? Okay, someone's asked me, since your proposition only mentions particular sections of a legislation, what is the scope of similarity when it comes to pari materia? Everything. If they have mentioned, say, section 2, section 5 only in the prop, then you will assume that section 1, section 3, section 6, 7, all of those other sections are also applicable unless they have specifically said otherwise in the proposition. So pari materia would include judgments also on that legislation, correct? It would include judgments, it would include all other sections, any amendments that have come, anything like that. So pari materia essentially does mean identical in that sense. We can't point out factual inaccuracies. Inaccuracies in what? Like in someone else's arguments or something? Riddhi has asked me this.
Factual inaccuracies in the sense if they cite a particular judgment, but then they maybe misinterpret the meaning of the judgment. Then can we
Sure,
point that
yeah.
out?
Sure. You can. I mean, not in an untimely way. If they're the petitioners, you're the respondent. Then when you get your turn as the respondent, you finish your arguments and then you say, just to point out that my learned friend or the learned counsel for the petitioner, be very respectful even if you're pointing out factual inaccuracies. Say something like, my learned friend has mentioned so and so, but as the facts stand, blah blah blah, just you can correct them respectfully or point out or say that there may have been a misinterpretation on their part of the law, something like that. Just respectfully you can feel free to differentiate on something they've said. Can international examples be used for our arguments? I mean, sure, persuasive value in terms of that would be lesser for international examples, but feel free to use them if your time permits. Feel free to use them. If you feel like you've exhausted mentioning judgments, if you've exhausted everything and you feel like you want to make this argument, then feel free to. There's no bar on that. How do we go on with rebuttals? Rebuttals, there are few things, few rules for rebuttals. For instance, you can't bring in new arguments. So as a petitioner, if you get your rebuttal, then you can't say something you've not said at all before in your submissions. You stick to what you've said, and the main intent of a rebuttal is essentially to rebut what the respondent has said, right? So stick to particular things they've mentioned. If they mention a judgment, you want to differentiate, go ahead and do that. If they've said an argument and you have counters for it, go ahead and do that. So just rebuttals, the intent of a rebuttal should be kept in mind. Make sure you're addressing particular things that they have argued. And in that sense, just showing before the court why their argument should not stand and why yours should take precedence in that sense. Will we be arguing on the first day with opponents or just no, I'm sure you all will have opponents, unless some of you all are going ex parte, which may be the case sometimes, but you will definitely have opponents also. That's how the structure will go, right? Your petitioner will go first, your respondent will go, then your petitioner will get the rebuttal. And after that, if your judges permit, I'm not sure if this is in the rules, but sometimes the respondent can get a sir rebuttal. This would be, I think, contingent on your judges. So as a respondent, if there's something a petitioner said that is horribly wrong, you really want to correct it, you want to say something, then politely request the judge, say if I may have 10 seconds for a sir rebuttal to just address one point, anything along those lines. How do we do rebuttals as the petitioner? I hope I answered this, Ria. The rebuttal part, as petitioners, you should just stick to whatever the respondent has said and try to basically weaken their arguments by I don't know, differentiating judgments, any factual interpretation that you think would be more well suited. Just mention all of that. How should respondents frame their arguments? Could you please tell me? What is the structure of framing arguments if you're a respondent? If you're a respondent, I mean, it's the same. There's no difference in terms of how you structure your arguments when it comes to sides. But as a respondent, like I said, in a consti mood, um, mainly what your arguments would entail is that your action as the government or as the state is one that is reasonable and one that is permitted because for fundamental rights are not absolute in nature. So what you do is you start off as the respondent. You can play it two ways, right? You obviously will have some particular arguments ready before the round, but you should, as a respondent, I think it's more important to respond in that sense whatever your petitioner is arguing. Now, if your petitioner is arguing something completely different, or say they're focusing more on one particular issue a lot, and the judges seemed convinced, or they didn't ask the petitioner too many questions on that issue, then you'll want to structure arguments as the respondent accordingly. You'll want to also give that one particular issue that much importance, that much weight, so that the judges can also, have like a balanced view on this particular thing, and they're not convinced that, okay, this issue though is in favor of the petitioner, I'm quite convinced. So your structuring would depend a lot on what your petitioner is also saying as the respondent. But in general, it'll be the same thing, right? You also state the law, you also state that there are restrictions that I, as the state, can impose. You state how these particular judgments, wherein, say, the government has even infringed upon someone's fundamental rights for that matter, then that would be a reasonable restriction, or that curtailment of fundamental rights would be reasonable. So you lay down these judgments, you connect it to your facts, and that's it. Then you state that there's been no infringement of fundamental rights on your part as a respondent. How strict is the dress code? Is it strict for both days? I'm sure the dress code is pretty strict. Please stick to black and white formals, and tie, I'm guessing, for men. So, and yeah, I'm sure it's for both days, your prelims as well as your semis and finals. Is there anything we need to be screen sharing during oral arguments? MC, are they allowed to do this? If they have like a compendium, anything like that, are they allowed to screen share it?
It's not compulsory, but if they choose to, they can.
Right. So Prushil has answered you. Y'all can, if y'all have a compendium, if y'all have a judgment that you want to show specifically, then feel free to. You can see if time permits, because screen sharing is a little more time consuming. So you'd rather say just state the important paragraphs or just say whatever you want to rather than screen sharing. But if you think it's pertinent, then sure, you can screen share. You can tell the MCA in advance that your court clerk in advance, and go ahead and do that. Um, I do not see any more questions. I'll wait for a minute. If anyone else has anything to ask, then feel free to. But again, like freshers is like a great starting point, guys. Y'all will do many moods, or some of y'all will end up not liking it and not do any more moods. But whatever the case may be, it's just a starting point, however it goes. So just enjoy the process. I mean, that's the only reason I do moods particularly. I just do it because I enjoy the process. It's not about the outcome. It's a good starting point. Go ahead and like just enjoy it and see how it goes. And no, there are no written submissions for you, Shweta. MC can correct me if I'm wrong, but I don't think I'll have any written submissions.
So written submissions are not compulsory, and I also wanted to add on to the submitting screen sharing part, wherein I believe
Hmm.
anonymity has to be maintained and your name cannot be expressed anywhere. So if once you're screen sharing, you have to make sure that your name is not visible and only the case law or the memorial or a written submission that you're sharing is visible.
Right. So if y'all are showing like an SCC copy and that has your name on top, try not to like show that, which clearly says that it's downloaded from your SCC. Um, what's the difference between a mem and a compendium, and does the compendium have a format? And they're very different. Compendium is basically just a ready reference for your judge. It's a compilation of everything that you're citing, any particular section, all the judgments that you're citing. You do this for ease of reference, right? You have a compendium, you give it to the judge. So when you're referring to a particular judgment, you just tell them that may I kindly direct your attention to this particular page of my compendium, and then they have access to that judgment. This is in contrast to like giving physical copies like you do in court. You just submit a compendium before. And a memorial is basically your arguments. They are your written submissions. So they are very different. A memorial will have your arguments and everything, whereas a compendium is just like a reference. So what do you mean our name should not be shared? Do we get a number? Yes, you all get a team, you all get a code or something, some number. I'm sure the MCA will allot you. So that's how you should refer to yourself during the duration of the competition if you have to refer to yourself. Or just call yourself counsel for petitioner, counsel for respondent. Don't mention names or anything along those lines. Okay, guys, any more questions or should we call this a day? Is it compulsory to submit a compendium or can we cite cases without submitting one? It's not compulsory. A compendium, a memorial, not compulsory for your freshers. If you want to make one, feel free to make one and feel free to screen share whatever the case may be. But it's not compulsory at all. You can just cite cases without submitting a copy also. If name not mentioned, then what introduction? Introduction is just you just greet them and you just say, I'm counsel appearing on behalf of the petitioner in the particular proceeding. That's all you have to say. Or counsel for respondent, whatever the case may be.
I have a question for Rushil. That slots is given. Which slot we have to appear actually? Join the meeting for which slot particularly?
So a pairing list will be released shortly, wherein you'll be allotted your time slot. So many of the people will be allotted a 10 a.m. slot, 2 p.m. slot, or a 6 p.m. slot. So a WhatsApp group will also be created wherein a link will be shared for the same. 1 day prior to the vote.
Okay, okay. Thank you. I've had that as well. And also, if there are questions related to facts, can we approach the MCA members?
Questions related to fact as in?
Means if we come across a questions relating to facts, can we approach MCA members for better clarification?
You can surely send a mail on mcaglc@gmail.com if you have any doubts as to for the most proposition. And if the clarification persists, we'll revert back with an email.
Okay, okay. Thank you.
Okay, I have no questions, Rochelle, on my personal chat either. I think that's it. Good luck, guys. Have fun. I know it's very cliched, but winning or losing in your freshers really does not matter. Work hard, surely. But I tanked my freshers horribly. I was knocked out in the prelims, just so you all know. So just it's okay. Just enjoy the process and have fun. I'll see you all.
Thank you, Chandni. On behalf of the Moot Court Association of Government Law College, we would like to thank Chandni Saini for organizing this workshop. I wish all the participants best of luck in their Freshers Moot Court competition, and we hope to see you soon. Thank you.
Thanks, Rochelle. Thanks, guys. Bye bye.